Welcome everyone to the 2022 Rookie Rumble final round. In this Zoom room right now are both teams as well as our judging panel. I'm going to introduce the two teams. The first will be representing the plaintiff Chase Ahrensman. That team is team 9854. The students competing today on behalf of team 9854 are Katie Volpert, Sina Sheikh, Charles Strello, and Gurvin Anand. On behalf of the defendant this evening, Scanlon Screening is team 9130. Representing team 9130 today is Suleiman Ali, Ria Debnath, Drew Ashlock, Ashley Yates, and Ashna Krishnan. Best of luck to both teams. I'm going to turn it over to Chance now to introduce our judging panel.
Good evening. My name is Chance Stirrup, and I'm here to introduce our amazing panel of judges that we have to evaluate this final round and determine our Rookie Rumble champions. First on our judging panel is Miss Elizabeth Grant. Elizabeth just graduated from Stanford University, where she was the president of Stanford Mock Trial. She's a two-time All-American, a two-time competitor at the Trial by Combat competition. Elizabeth has also been very important in our community for speaking up on issues important to competitors, such as sexual harassment and gender discrimination. Along with Ms. Grant, we have Daniel Elliott. Daniel Elliott was the captain of Rhodes Mock Trial through 2019. He competed in the 2019 final round. He's an All-American, and he's currently enrolled at the University of Virginia Law. We thank him for his time. We also have Ms. Sonali Mehta. Sonali was the captain of Duke Mock Trial. She was your Trial by Combat champion in 2019-2020 season. She's also enrolled at Harvard Law. Along with her, we have Miss Danielle Kunkel. Danielle was the 2018 National Championship closer for Miami University. She's an All-American. She's a graduate of Wake Forest Law, and she's an associate at Jones Day. Alongside these four great judges, we also have Brandon Harper. Brandon started as a competitor at Washington St. Louis Mock Trial. He's coached just about everywhere, be it Washington St. Louis, University of Pennsylvania, William and Mary College, and Columbia University. Brandon has made tremendous contributions to AMTA. He's the outgoing president, having just resigned from the presidency a few weeks ago. And finally, for your presiding judge, your new AMTA president, having just taken over, Mr. Jonathan Woodward. Judge Woodward started his career in 1999 with AMTA at the University of Missouri. He is the author of the tab manual that is used today. He's an encyclopedia of all college mascots. He's your next AMTA president. And we welcome Judge Woodward as the presiding judge of our trial. So with that, Judge Woodward, I will turn it over to you so that we can get this trial started and crown a champion as soon as possible.
Thank you, Chance. And I will call the case of Chase Ahrensman versus Scanlon Screening Incorporated, case number CV 22-101248. If I could have appearances from counsel for the plaintiff, please.
Yes, Your Honor. Good afternoon. My name is Katie Volpert, and I, along with my co-counsel, Gurvin Anand.
Good afternoon.
We'll be representing the plaintiff in today's case, Chase Ahrensman.
And good afternoon. Appearances from counsel for the defendant, please.
Yes, Your Honor. Good afternoon. My name is Ria Debnath, and today I'm joined by my co-counsel, Mr. Drew Ashlock.
Good afternoon, Your Honor.
And together we represent our client, Scanlon Screening. Today, Ms. Emerson Moon will be in court on behalf of Scanlon Screening.
Good afternoon.
Good afternoon. Thank you, Attorney Debnath. I'll note for all counsel that the court is familiar with all of the pleadings. I've reviewed the stipulations prior to trial. I'm aware that we have a total of 8 exhibits that are pre-admitted. With that in mind, either Attorney Volpert or Attorney Anand, anything else that we need to take up from the plaintiff's perspective before we bring in the jury?
Yes, Your Honor. First, we'd like to invoke Rules 603 and 615, the constructive swearing in and sequestration of all witnesses, barring party representatives. The plaintiff does have a party representative today, Chase Ahrensman.
And I assume Mr. Moon will be the party representative for the defendant. Is that correct, Attorney Debnath?
Yes, Your Honor, Ms. Moon will be here as our party representative.
Okay. Those motions are granted. Anything else, Attorney Volber?
Yes, Your Honor, just a few things. First, may we assume that when we screen share exhibits that aren't pre-admitted pursuant to stipulation 2, that they're constructively outside of the jury's vision until they are moved into evidence?
You may.
Yes, Your Honor. And finally, may we inquire about your preferences on screen sharing? Would you like us to simply state it for the record or ask permission before doing so?
There's no need to ask for permission. You can just state whatever you need to for the record.
Yes, Your Honor. And with that, the plaintiff is ready to proceed.
All right, very good. Either Attorney Debnoff or Attorney Ashlock, anything else on behalf of the defendant before we bring in the jury?
Yes, Your Honor, just one thing. My co-counsel will be screen sharing a piece of case law at this time.
Your Honor, in most jurisdictions, the plaintiff just has to prove under the whistleblower statute that they held a reasonable belief that the defendant was in violation of the law. But that's not the case in Midlands. The courts of Midlands ruled in Nickel versus Mather that the plaintiff also bears the burden of proving that the defendant was in fact in violation of the law.
Okay.
I just thought we'd bring that to Your Honor's attention. With that, we're ready to proceed to opening statements.
All right. Very good. We'll bring in the jury. We're still on the record in the Ahrensman versus Scanlon screening matter, and counsel for the plaintiff, you may proceed with your opening statement whenever you're ready.
Yes, Your Honor. 300 days. That's how long Chase Ahrensman worked at Scanlon Screen. 5 days. That's how long it took for the defendant to fire him. It's November 26, 2020, and Emerson Moon has a decision to make. Fire her employee Chase Ahrensman or let her company Scanlon Screening fall to pieces. You see, Chase Ahrensman has just uncovered a secret. That Scanlon Screening's main product, a rapid COVID test called the SafeStrip, wasn't as accurate as they said it was. Scanlon was producing faulty COVID tests and hiding the data to cover it up. So when Mr. Ahrensman went to Emerson Moon with what he had learned, Emerson Moon had a decision to make. A decision between what was legal and what was lucrative. You'll hear that just 5 days later, Emerson Moon decided to fire Chase Ahrensman. 300 days Chase Ahrensman worked at that company, but only 5 mattered to Emerson Moon. In the state of Midlands, it's actually illegal to fire an employee for reporting a violation of law, like false advertising. That's why Mr. Ahrensman is bringing a lawsuit against Scanlon Screen. Now, to prove that Scanlon is liable, we have to show you 2 things today. First, that Scanlon made a statement that was false. And second, that Chase Ahrensman was fired for reporting that false statement. We have to prove both of those claims by a preponderance of the evidence, meaning more likely than not. We're going to meet that burden today, and we're going to do it by answering 3 questions. First, what did Scanlon say? Second, were those words true? And third, why was Chase Ahrensman fired? First, what did Scanlon say? To answer this, we'll show you this press release that Scanlon Screening made in February of 2020. You'll hear that in this press release, Scanlon claims that their product, the SafeStrip, is the most accurate option on the market. That it's better than any of its competitors. That brings us to our second question. Were those words true? To answer this, we'll call Dr. Bren Feldhaus to the stand, an expert in infectious disease epidemiology. That's just the study of how diseases spread. And Dr. Feldhaus will tell you that when compared to other rapid tests on the market, Scanlon's SafeStrip doesn't stand up. That it's actually less accurate than every single competitor he tested it against. There's no way that that statement could be true. Third, why was Chase Aaronsman fired? Now, you're actually going to hear from Emerson Moon today, the founder and COO of Scanlon Screen. And she's going to make excuses for why she fired Chase Aaronsman, but those excuses won't add up. Because you'll hear from Mr. Aaronsman himself today, and he'll tell you that he worked at Scanlon for 300 days. And that for the first 295, he never got any complaints, never got any reprimands, never got any negative performance reviews. In fact, Mr. Aaronsman will tell you that he was actually promoted in July of 2020, just months before he was fired. And then he'll tell you what changed. And on November 26th, 2020, Mr. Aaronsman went to Emerson Moon and told her what he knew. He'll tell you that just 5 days later, he was fired. 300 days, but only 5 mattered. That's why at the end of today's trial, my co-counsel, Gervin Anand, will come before you and he'll ask that you find Scanlon Screening liable. Thank you.
Thank you, Attorney Volbert. Attorney Ashlock, you may proceed with your opening statement whenever you're ready.
Yes, Your Honor. An equal exchange. Members of the jury, Ms. Volpert just got up here and told you that this case is about Mr. Aaronsman blowing this big story about Scanlon lying about their COVID tests. But you're going to learn today that that just isn't true. If it were, then today you'd be hearing from angry customers who use Scanlon products. You'd be hearing from other lab managers coming forward. You'd be hearing about the MDA clearing Scanlon products off the shelves. But you're not going to hear about any of those things. No, that's because this case, it comes down to one thing and one thing only. An equal exchange. November 2020, Peel County, Midlands. An employee at Scanlon Screening is working hard for a promotion he's convinced he deserves. He files for that position, makes his pitch, only to be denied. Again and again. So he starts sending threats. He fakes experiments. He does everything he can to get even with his boss. But he's not the only one trying to bring Scanlon down. At the same time, a billionaire's hired gun is on a mission. You see, his boss wants to take over Scanlon Screening, so this researcher sends a letter out to Scanlon employees, hoping to get his hands on any dirt he can. He gets one call back. An employee is willing to make a trade. False information about Scanlon tests for a promotion. An equal exchange. Members of the jury, you're going to learn today that the two men who made this deal, the two men who stand to gain everything from Scanlon going down, well, they're Chase Aaronsman and Dr. Feldhaus. The only two people Ms. Volpert just told you they're calling to the stand. Now that's a problem because the plaintiff, they bear the burden of proof. They have to prove not one, but two things to you today, members of the jury. First, they have to prove that Mr. Aaronsman was telling the truth about Scanlon COVID tests. And second, they have to prove that coming forward was the only reason he got fired. Members of the jury, if they can't prove that both of those things are more likely than not true, then you can't find my client liable. They're not going to be able to meet that burden today. Let me tell you why. You're going to hear from an MDA researcher who reviewed Dr. Feldhaus's work. Now, he's going to tell you that despite a glaring flaw in Dr. Feldhaus's experiment, he went to the press with the data he got. But you're not just going to hear from third parties today. No. No, the co-founder of Scanlon Screening herself is going to take the stand. And she's going to tell you that when Chase Ahrensman came forward with these claims, well, she ordered an investigation immediately. That investigation turned up nothing. But you're going to learn that when Mr. Ahrensman wasn't satisfied with that answer, he went to the one person who was willing to listen to his tall tale, Dr. Feldhaus. Members of the jury, you'll learn today that Mr. Ahrensman wasn't fired for blowing any whistle, but for lying and sending threats. Now, Ms. Volpert and I can agree on one thing. Chase Ahrensman did work at Scanlon Screening for 300 days. But those 300 days, he spent constantly fighting for a promotion that ultimately only Dr. Feldhaus was willing to give him. And that's why when you're listening to the testimony, when you get a chance to look at the evidence, we're going to ask that you see through their equal exchange. At the end of this trial, my colleague, Ms. Debnoth, is going to come before you. She's going to ask that you find our client not liable. Thank you for your time.
Thank you, Attorney Ashlock. We'll pause for just a moment to allow the jury to collect their thoughts, and then I'll invite counsel for the plaintiff to call its first witness. Counsel for the plaintiff, please go ahead and call your first witness.
Yes, Your Honor. The plaintiff calls Chase Ahrensman to the stand.
I'll remind you, you've previously been sworn. You may go ahead with your examination.
Yes, Your Honor. Good afternoon. Could you introduce yourself to the court?
Good evening. My name is Chase Ahrensman.
What do you do for a living?
Well, I was a senior research scientist and a lab manager at a place called Scanlon Screening. They make COVID tests, but since I've been fired, I moved back home to my family's ranch. And let me tell you, in America, with all this inflation, mowing grass for your parents doesn't pay what it used to.
Mr. Ahrensman, why are you in court today?
When I worked at Scanlon, I started to suspect that they were producing faulty COVID tests and lying to the MDA to get approval. When I spoke to my bosses about it, I was fired.
Now, you heard Mr. Ashlock give his opening statement, and you heard him say that you lied about Scanlon's test to get a promotion. Is that true?
No, absolutely not. I only went to Dr. Feldhaus because I was worried people might get hurt.
Let's take a step back and start from the beginning. What was your role at Scanlon?
Well, as I mentioned, I was a research scientist at Scanlon. My job was to develop Scanlon's rapid COVID tests. We called them safe strips. It was Scanlon's main product.
Could you tell me a little bit more about the safe strip?
Well, the design's pretty nice on them. You don't have to stick anything up your nose like all the other tests. All you got to do is spit into a tube, dip the safe strip in, and then you wait a minute. If it turns green, then you're good. And if it turns red, then you got COVID.
Now, as a research scientist, could you tell if the safe strip was working?
No, I couldn't.
Why not?
Well, the departments at Scanlon are kept completely separated. Scientists don't see the data from customers, so we had no idea how accurate our tests were. I only ever saw positivity rates from my own lab. Our bosses said that we need to keep everything on the hush hush.
What do you mean by that?
Every employee had to sign an NDA and some other confidentiality agreements. We even had to attend bi-weekly confidentiality trainings run by my lab manager, Drew Pincus.
What were you told in those confidentiality trainings?
But we couldn't tell anyone outside our lab what we were working on, including them folks who looked at the results of the safe strip.
Did you ever get access to the safe strip's accuracy data?
Frankly, I never saw any of that sort of data. All I saw was what Scanlon told the public about the safe strip in a press release.
Would you recognize that press release if I were to show it to you?
Yes, ma'am.
Your Honor, let the record reflect we're now screen sharing Exhibit 3, which is pre-admitted pursuant to Stipulation 2. What are we looking at here?
This is the press release I was just talking about.
When was this press release made?
Well, it says here at the top that it was from February of 2020.
What did Scanlon say about the safe strip in this press release?
They said that they were approved by the MDA because, yeah, there it is. The regulators determined that it was the fastest, safest, and most accurate option.
Did you have enough information to know if that was true?
Well, not at that point, but after working for the company for a couple of months, and I started getting skeptical due to all the FBI level secrecy and all. So I decided to test the safe strip myself.
How did you do that?
Well, I took a sample from our positive sample storage, and I tested it using the safe strip and a few competitors' tests. I actually did it 10 times per test just to be safe in my results, because I mean, you know what they say, man, you don't breed a dairy cow just once.
What did you find?
Well, I couldn't believe it. While the safe strip only identified half of the samples correctly, the competitors' tests got all 8 out of 10 correct on every one.
How did you react to finding out that the safe strip only got 5 out of 10 correct?
Well, I went straight to Pincus and Moon, my bosses. I told them about my own tests and everything. And I said that we better make sure that what we were reporting to the MDA was actually accurate.
How did they respond to that?
Well, Pincus said nothing, just sat there like a trout with no lips, but Moon glared at me and said, "Don't say a word about this to anybody."
Did you listen?
Of course not. If Scanlon's tests were faulty, someone could lose their life. A guy could think he's negative and then go cough on his grandma the next day. I knew I had to do something. So I called Dr. Bryn Feldhaus and I told him everything. And the very next day, it was all in the news. By December 1st, there was a memo on my desk telling me I was fired.
Would you recognize that memo if I were to show it to you?
Yes, ma'am.
Your Honor, let the record reflect we're now screen sharing Exhibit 8, which is also pre-admitted pursuant to Stipulation 2. What are we looking at now?
Well, this is a memo where I was, told I was fired.
Did Emerson Moon tell you in this memo why you were fired?
You can see for yourself. All he said was that he banished the rat.
Mr. Ahrensman, I want to take a step back and talk about the entirety of your time at Scanlon. And I want to keep a timeline of what happened. Mr. Anand, could we get that on the screen? Now, how long did you work at Scanlon for?
Well, I started working there in March of 2020, and I was fired on December 1st of 2020. So it's about 300 days. Yeah.
In those 300 days, did you ever receive any negative performance reviews?
No, not one. I was actually promoted just a few months earlier in July. I thought I was doing everything right.
So let's talk about what changed. What day did you report what you learned to Emerson Moon?
November 26th of 2020, ma'am.
And how many days later were you fired?
5 days later.
Thank you, Your Honor. No further questions.
Thank you, Attorney Volpert. Attorney Ashlock, please proceed with your cross.
Yes, Your Honor. Good afternoon, Mr. Ahrensman.
Good afternoon, sir.
Now, in your conversation with Ms. Volper right now, you left off talking about that last week leading into when you got fired. I want to talk about what else happened. Your Honor, at this time, we're going to be displaying Exhibit 17 for identification. Mr. Ahrensman, you recognize these photos, don't you?
Yes, sir. I recognize them as the notes I wrote.
And that's right. You personally hand wrote these torn notes on these torn off pieces of paper and gave them to Miss Moon.
Yes, sir.
They're fair and accurate copies of the notes you wrote.
Yes, sir.
At this time, Your Honor, we ask that Exhibit 17, A through C, be moved into evidence.
Attorney Volpert, any objections to any of these three exhibits?
No objections, Your Honor.
Exhibit 17A, 17B, and 17C will be received.
Yes, Your Honor. Now, Mr. Ahrensman, if we take a look at that first note right there, well, you're asking for a promotion, aren't you?
Yes, sir. I'll put a lot of heart and soul in that company. I felt at that point I deserved one.
Well, you told Miss Moon that it was time a new alpha was let into the pack.
Yeah, I felt that I had done good work that she had seen.
All right, Mr. Ahrensman, if we take a look at all of these notes together, you'd agree they're pretty insubordinate, aren't they?
I mean, I guess you could say that they were a little insubordinate, but keep in mind, I thought lives were at stake here.
Mr. Ahrensman, I'm not asking what I could say. I'm asking what you would say. And you would say these notes, they're insubordinate.
Yeah, a little insubordinate in regards to something I felt was a massive issue.
And that last insubordinate note you wrote, that was November 27th, 2020, right?
Yeah, I felt like I wasn't being taken seriously by Moon Pincus about something that could be hurting people.
Mr. Ahrensman, that was a yes to my question. November 27th, that's when you wrote that note?
Yes, sir, absolutely.
Mr. Ahrensman, that's not 5 days before you were fired, is it?
No.
That would be 4 days, wouldn't it?
Yes, sir.
Well, let's talk about what writing an insubordinate note would mean for your employment at Scanlon Screening. Your Honor, we're going to be displaying Exhibit 14. It's already in evidence. Mr. Ahrensman, this is a page from the Scanlon Screening Employee Handbook, isn't it?
Yes, sir.
It lists the reasons an employee can get fired.
Yes, sir, it does.
When you joined the company, you read this page.
I did way back then, and I signed it too.
That's right, Mr. Ahrensman. You signed off to everything in that handbook.
Yes, sir.
Let's look at what you signed off to. If we look at Section 6C here, Mr. Ahrensman, it says Scanlon can fire an employee for insubordination, doesn't it?
Yes, sir.
So let's talk about what you did after you wrote these insubordinate notes. Your Honor, we're going to be pulling up Exhibit 12. It's also already in evidence. Mr. Ahrensman, you received this letter in November of 2020, didn't you?
Yeah, I received it in November.
This letter, it's asking for gossip at Scanlon Screening, isn't it?
Yes.
Not just gossip, it's asking for flaws in Scanlon's COVID tests.
Yes, sir. And that was the exact thing that I'd found after I spoke to, I don't mean to talk, but after I spoke to Moon and them, found out about this, found out there was someone I could go to that might take me serious.
Mr. Ahrensman, it says that for going to someone with this information, you'd be rewarded.
Yeah, Moon Pincus didn't listen, so I hoped this Feldhouse fellow would.
Mr. Ahrensman, that was a yes to my question, though. It says you'd be rewarded for this information.
Yes, sir.
And it says that you'd even be promoted.
Yes, sir.
We can take that down now, Ms. Krishnan. Mr. Ahrensman, you wanted to get ahead at Scanlon Screening, didn't you?
Yeah, I did.
And you would say that you're the type of person who's willing to get ahead.
Objection, Your Honor, to character evidence. May I be heard?
Yes, please do.
Your Honor, the question that Mr. Ashlock is asking is if this witness is the type of person who would want to get ahead at any price. He's using that to show a character trait and conduct in conformity therewith, that he then wanted to get ahead and would do anything in order to make that happen, including lying about Scanlon's faulty tests.
Mr. Ashlock, what's your response?
Yes, Your Honor. This evidence is admissible under Rule 404B2. It specifically goes to motive on behalf of Mr. Ahrensman, specifically to give faulty information to the investment company in that letter to gain the promotion.
Brief response, Your Honor.
Please.
That's an exception to the Rule 404B, improper use of crimes, wrongs, and other acts. To clarify, I'm objecting to 404A, not to an act, but to a character trait that's being elicited. Therefore, 404B2 doesn't apply.
Attorney Ashlock, what's your response to that?
Yes, Your Honor. Pursuant to Rule 608A, we're allowed to use specific instances of conduct to elicit a character of truthfulness or untruthfulness on behalf of this witness. Not only that, Your Honor, but this line of questioning is specifically connected to the charges of this case, that Mr. Ahrensman was lying about the information in the Scanlon COVID test.
Response on those grounds?
No, thank you. I'm not hearing anything in this question that would call for evidence about a specific instance. Frankly, it's somewhat argumentative. I'll sustain the objection. Next question, Mr. Ashlock.
Yes, Your Honor. Mr. Ahrensman, I want to talk about what you did when you got that letter in the mail. You called the number listed at the bottom, didn't you?
Yeah, that was after I'd spoke to Moon and Pincus.
And a Dr. Feldhaus picked up.
Yes, sir. Fine gentleman.
And when you talked to Dr. Feldhaus on the phone, you told him about this experiment you had run to prove that Scanlon tests were faulty?
Yes, sir. I told him everything I'd found.
Mr. Ahrensman, when you told Dr. Feldhaus that you had this information on Scanlon COVID tests, well, he told you it was going to make his career, didn't he?
Yes, he did. It's important to him, I think.
And now that you gave Dr. Feldhaus what's important to him, well, now he's here to testify for you, isn't he?
Objection, Your Honor, to argumentative and calls for speculation.
Your response, Attorney Ashlock?
Yes, Your Honor. Opposing counsel is calling Dr. Feldhaus to the stand. The plaintiff has retained him for this trial. It's not argumentative to say that he's here in court today helping Mr. Ahrensman.
Response, Your Honor.
Go ahead.
Your Honor, first to the speculation, he has no way to know why Dr. Feldhaus is testifying today. That goes into his mindset. And further, asking this witness if another witness is testifying because something is important to him, that's argumentative, Your Honor.
I agree. Objection sustained.
Yes, Your Honor. Mr. Ahrensman, you're paying Dr. Feldhaus to testify on your behalf in court today, aren't you?
Yes, sir. I don't know much about the science behind a lot of what he's done, so that's why he's here.
No further questions, Your Honor.
Thank you, Attorney Ashlock. Attorney Volpert, any redirect for this witness?
No redirect, Your Honor. I just ask that my witness be able to step down.
We'll pause a few moments here for the jury to collect their thoughts. And while we're doing that, Attorney Anand and your witness can step forward.
Yes, Your Honor. We'd like to call Dr. Bren Feldhaus to the stand.
We'll wait just a moment or two before you begin to allow the jury to finalize their thoughts.
Yes, Your Honor.
Right, Dr. Feldhaus, I'll remind you, you've previously been sworn. Attorney Anand, you may proceed when you're ready.
Yes, Your Honor. Could you please introduce yourself to the court?
Good afternoon. My name is Dr. Bren Feldhaus.
And what do you do for a living, Dr. Feldhaus?
I'm a doctor of public health, and I specialize in infectious disease epidemiology, which means that I study the spread of highly infectious diseases and the tools that we use to combat them.
Where did you study?
I received my bachelor's degree in chemistry from Ohio State. I then went to Oxford, where I earned my master's in global health science and epidemiology. And finally, I went to Berkeley for my doctorate of public health.
Could you tell us a little bit about your work experience in medicine?
Of course. I worked at the CDC for the first 30 or so years of my career. I went from a field researcher to a supervisor, and eventually I became the chief epidemiologist at the CDC. Currently, I spend most of my time at Cooper, Feldhaus and Associates as a partner and principal consultant.
So, Dr. Feldhaus, what is your connection to today's case?
My firm was tasked with determining the efficacy of the SafeStrip rapid antigen test that Scanlon Screening produces. I was later hired to testify to my findings in court.
And what facts or data did you review for this analysis?
I reviewed the claims made by Scanlon. I conducted my own independent tests of the SafeStrip, and I reviewed positivity rates for the SafeStrip and for Peel County overall for September and October of 2020.
Was all of that sufficient to come to your conclusion?
It was.
What principles or methods did you rely on in testing the SafeStrip?
So there's a standard industry practice, which I've used for over 30 years now. I review all the facts and data available. I conduct whatever independent tests are necessary, and I look for results, which just don't add up. This is exactly how I approached the case of Scanlon SafeStrips.
Were these principles and methods reliable?
Yes, they're routinely used by experts at the CDC and the MDA, and it's the standard approach to test the efficacy of all sorts of medical devices.
And did you reliably apply them to the facts of today's case?
I did.
Now, what did you learn from the materials that you reviewed?
Well, I actually prepared a few graphs and charts to better explain my findings, if I may.
Your Honor, let the record reflect we're now screen sharing a demonstrative from Dr. Feldhaus. So, Doctor, what are we looking at here?
These are three of the major pieces of evidence that I reviewed to draw my conclusions in today's case.
Let's go piece by piece. What did you learn from the statements made by Scanlon about their tests?
In their promotional materials, Scanlon claimed that their SafeStrips were the most accurate tests on the market.
What about your independent evaluation of Scanlon and its competitors' tests? What did you learn there?
Well, I wanted to see if the claims that they made were true. So I tested 50 samples, 33 negative and 17 positive, on Scanlon SafeStrip. I then repeated that exact same process with 3 of their competitors, testing the same 50 samples on each type of test.
What did you find?
Well, to put it simply, the SafeStrip just isn't as accurate as its competitors, whatever way you slice it.
Objection,
While
Your
they're
Honor. 702B. May I be heard?
Go ahead.
Yes, Your Honor. Before Dr. Feldhaus can go on to testify about any sort of expert conclusions from his findings in this experiment, the foundation for Rule 702B has to be laid. But Your Honor, this very same experiment that he's testifying about right now relied on an insufficient sample size, so 702B cannot be met.
May I respond, Your Honor?
Before you do, Attorney Anand, the court needs to clarify. Attorney Debnoth, is your objection to lack of foundation or to improper expert testimony?
Improper expert testimony, Your Honor, because 702B cannot be met.
Attorney Anand, your response?
Yes, Your Honor. We've already laid the foundation that prong B of Rule 702 has been met. Dr. Feldhaus testified that this was, in fact, sufficient facts and data to come to his conclusion in today's case. If opposing counsel wants to bring up the fact that she doesn't believe this was enough, she can do so on cross-examination, but that doesn't make this evidence inadmissible.
May I be heard as to that, Your Honor?
Your response?
Yes, Your Honor. Dr. Feldhaus's somewhat self-serving conclusion that his own materials were reliable, it's not enough to meet the preponderance standards set out by the case precedent of Davis v. Adams. Your Honor, that same case precedent ensures that unreliable expert testimony doesn't reach the ears of the jury. Your Honor, I'm prepared to voir dire Dr. Feldhaus if required to demonstrate why 702B cannot be met.
Go ahead.
Could we get the screen share of the graph down, please? Thank you. Good afternoon, Dr. Feldhaus.
Good afternoon.
I want to start by talking about that experiment you just mentioned. Now, it relied on 50 samples. Do I have that right?
That's right.
But to find the cause of any sort of discrepancy, you would have needed 10 times that amount, 500 samples, wouldn't you?
Well, there's not a magic number for what we can use to determine the cause of something or not, but I agree that more samples would have been helpful. However, to reach my conclusions in today's case, those 50 samples were more than enough.
Doctor, to be clear, to find the cause of any sort of discrepancy, you would have needed 500 samples with a yes or a no.
That's right.
Objection, Your Honor, asked and answered. This is the exact same question that Attorney Debnoff just asked.
May I be heard?
I think she's clarifying the witness's response, so the objection's overruled. The witness may.
That's right. In order to determine the cause of why Scanlon was performing worse than its competitors, I would have needed more tests. But in order to determine that Scanlon was worse than its competitors, which is what that bar graph showed, I just needed those 50 tests.
Doctor, you never tested those 500 samples, did you?
They weren't necessary for my conclusions in today's case.
You're telling us those 500 samples weren't necessary, but it's true that you'd agree that without that further testing, it would be exceptionally difficult to draw conclusions about the cause.
Again, yes, we can't say why the Scanlon safe strip was less accurate than its competitors. All we know is that it was.
Thank you, Dr. Feldhaus. Your Honor, I've got nothing further at this time. I do re-raise my objection under Rule 702B, if I may be heard.
Go ahead.
Yes, Your Honor. Dr. Feldhaus just testified that in order to find out the cause of any sort of discrepancy that he was seeing, he would have needed 500 samples or further testing. And he testified also that he didn't conduct any further testing, which means that he doesn't know if the discrepancy he found was an issue with his own experiment or an issue with Scanlon's tests as a whole. 702B hasn't been met.
May I respond, Your Honor?
Go ahead.
Opposing counsel is misconstruing what Dr. Feldhaus just testified to. Dr. Feldhaus said that 500 tests would be necessary to come to a conclusion on the cause of the safe strip's inaccuracy. He didn't say that 500 tests were necessary to come to a conclusion on the fact that the safe strips were inaccurate. That is all that Dr. Feldhaus has testified to and will testify to.
May I be heard briefly, Your Honor?
No, the court is prepared to rule. I agree with Attorney Anand in evaluating the admissibility of evidence under Midland's Rule of Evidence 702. The court has to evaluate whether the witness's testimony is based on sufficient facts or data. I'm satisfied based on the testimony of Dr. Feldhaus that the extent of this witness's testimony is based on sufficient facts or data. Certainly to the extent that the defense believes the jury should put less weight on that, that can be taken up on cross-examination. The objection is overruled. Attorney Anand, you may continue with your direct examination.
Yes, Your Honor. Now, Dr. Feldhaus, if you could answer again, what did you find from this test?
Of course. To put it simply, the safe strip just isn't as accurate as its competitors, whatever way you slice it. While their competitors correctly identified between 88 and 71% of positive samples, the safe strip only caught about 50%.
Okay. Now, Dr. Feldhaus, you had mentioned analyzing positivity rates. What exactly are positivity rates?
Well, the name is pretty intuitive. It's the percentage of all tests run which come back positive.
Okay, and are the rates you looked at for all COVID tests in Midlands?
Not exactly. My analysis included two data sets. One was from the CDC, and that shows the overall positivity rates from all tests in Peel County. And the other shows positivity rates of Scanlon's safe strips from that same county, Peel County.
Doctor, where did you get these data sets?
Well, the CDC data is a public record available to anyone. You could look it up on your phone right now. But for the second data set, I emailed Scanlon Screening to obtain their positivity rates and data. But Mr. Moon, their CEO, informed me that most of that data had been deleted from their system, which seemed highly unusual to me. This set was what Chase Aaronsman was able to salvage.
So what did your analysis of these positivity rates tell you?
Objection, Your Honor. Under Rule 403, may I be heard?
Go ahead.
Your Honor, in this graph, the overall positivity rate of Peel County is being compared to what's labeled here as Scanlon's data. However, that blue line there, it's based off only a small fraction, just 20% of Scanlon's overall data. So it misleads the jury because we have no idea what Scanlon's overall positivity would have looked like.
May I respond, Your Honor?
Go ahead.
Dr. Feldhaus specified that this was the only data available that he received from Chase Aaronsman. While it does not represent every COVID test from Scanlon safe strips in that time period, it is enough for Dr. Feldhaus to come to his conclusion comparing the positivity rates of the Scanlon safe strip versus the general positivity rate of Peel County.
May I-
Final word?
Yes, Your Honor. We'd be all right with a constructive edit to this line graph that states the blue line there in the legend at the top is only from 20% of Scanlon's data, and that way it would not mislead the jury.
Well, I'm going to deny the request to impose an alteration to this. One, you can bring that up on cross. And two, it sounds like your client could have provided that information to the plaintiff prior to trial, but apparently didn't do so. So for those reasons, the objection is overruled.
Yes, Your Honor. So once again, Dr. Feldhaus, what did you learn from your analysis of these positivity rates?
Right. So the red line on the top here, that shows the overall positivity rate for Peel County. You can see that those rates fluctuate a lot, and they actually grow by a factor of 8 in this time period. Now, Scanlon's competitors had positivity rates that tracked quite closely with that fluctuation, which is what we would expect. If there's a trend across the entire county, each test should largely reflect that pattern with maybe a variation of a few percentage points up or down.
And what about the safe strip? Did the safe strip follow that pattern?
No. Scanlon's tests weren't even close. As you can see here, the blue line on the bottom, from the blue line on the bottom, their tests remained flat at about 5%. They didn't go up as COVID rates skyrocketed, and that's indicative of a faulty test, misreported data, or both, frankly.
If there was such a big discrepancy here, why did the MDA approve this test?
Well, if they reported these numbers, I don't know how the test could have possibly been approved and retained approval by the MDA.
Based on all of the data that you had reviewed, Dr. Feldhaus, what are your final conclusions in today's case?
I found that the safe strip only correctly identifies COVID about 50% of the time. Put simply, it's not the most accurate COVID test on the market. It's not even close.
Thank you, Dr. Feldhaus. Your Honor, I have no further questions.
Thank you, Attorney Anand. Attorney Debnoff, you may proceed with your cross-examination.
Yes, Your Honor. Just a moment to compare what the witness said in their direct examination to what they stated in their affidavit.
That's fine. Take your time.
All right, Your Honor, we're ready to proceed.
Go ahead when you're ready.
Yeah, good afternoon once again, Dr. Feldhaus.
Good afternoon. Good to see you again.
I want to start by talking about that line graph that you just showed the members of the jury. Ms. Christian, can we get that line graph up on the screen? So, Doctor, you told us that that blue line there represents Scanlon's data, right?
That's right.
But that's not all of Scanlon's data, is it, Doctor?
It's not all of Scanlon's data, but it's 20% of it. And I have no reason to believe that it's not indicative of the full gamut of Scanlon's data.
But Doctor, you'd agree that that data that Mr. Arensman sent you was only a small sample of Scanlon's overall data.
That's right, but I have no reason to believe that it's not a representative sample.
You're telling us you have no reason to believe it's not representative, but doctor, I want to be clear. You would agree that it's not ideal to draw conclusions with such limited information. Do I have that right?
That's absolutely right. But the reason that I couldn't get all of that data is because Scanlon Screening deleted it. They refused to provide that data to me.
Doctor, directing you back to my question, you'd agree that it's not ideal to draw conclusions from such limited data with a yes or a no.
Absolutely. And Scanlon could fix that by giving me all their data, but they chose not to.
Thank you, Ms. Krishnan. We can get that down. So, doctor, I want to talk about why you might have drawn those conclusions anyway.
Of
Now,
course.
Mr. Ahrensman, he's not the only person paying you for this case, is he, doctor?
To testify in trial today, he's the only person paying me, but I was previously retained to determine the accuracy of the safe strip.
You were previously retained by an investor in your firm to investigate Scanlon, weren't you?
Not an investor in my firm, but another firm which hired my firm.
So that client wanted to investigate Scanlon Screening. Do I have that right?
That's right.
Ms. Krishnan, can we get Exhibit 12? It's been pre-admitted, Your Honor. Now, Dr. Feldhaus, on behalf of that client, you sent out this letter to Scanlon's employees, didn't you?
I did, yes.
Now, Doctor, in this letter, you're not asking for how successful Scanlon is, are you?
That's one of the things that I asked for.
Well, let's take a look at what this says. Doctor, it says here that you're looking for problems with Scanlon's management?
That's right. The investment firm, Hammett, insisted that I included a few additional things in addition to the things that I was interested in myself. My job was just to determine the accuracy of the safe strip, so I didn't need any of this information, but Hammett insisted that I include it.
Doctor, thank you for that explanation, but I just need a yes or a no. And it's true that you were looking for problems with Scanlon's management, right?
No.
Doctor, it says here that this letter is looking for evidence that confirms current Scanlon management is failing to realize value. Did I read that correctly?
You did, but you just asked me if I was looking for that information. I wasn't. The firm Hammett was.
Doctor, you are listed as the contact person on this letter, right?
I am.
You did send out this letter?
I did.
So directing you back to what this says, it says you're looking for problems with extramarital affairs and gossip?
That's right. I sent this letter out on behalf of the firm Hammett, and they insisted that I include a couple things.
And in this letter, on behalf of that firm, it says you're looking for problems with the safe strip, doesn't it?
That's exactly right. The person who hired me wanted to invest in this company, and they wanted to know if it was actually the most accurate test on the market. So any problems that he should know about before he invested would be incredibly valuable to him.
So that's a yes, doctor?
Yes.
And to be clear, in exchange for that information, the employee who came forward, it says this firm will reward them.
That's right, though I have no knowledge of that.
It says here that this firm plans to promote those employees.
Again, that's what it says.
And so I want to talk about someone who might have wanted that promotion. Doctor, Mr. Ahrensman, he contacted you, didn't he?
He did.
He told you about an experiment that he ran that produced false negatives?
He did.
Doctor, I want to be transparent with the members of the jury. You never asked to come down and see those false negatives, did you?
That's right. I decided that it would be better to conduct my own investigation into the subject matter, which is what I did.
But sir, without verifying Mr. Ahrensman's information, you went to the press the very same day, didn't you?
That's right. When it comes to COVID tests, it's always better safe than sorry. If one more person died than had to because they took the Scanlon safe strip, I couldn't live with myself.
So that was a yes to my question?
That's right. I told the public what I knew.
And without verifying Mr. Ahrensman's information, doctor, you decided that his experiment validated your own conclusions?
Well, I mean, it certainly supported them, but I had a number of pieces of data that validated them for me as well.
Doctor, you would say that Mr. Ahrensman's experiment validated your own conclusions with a yes or a no?
Yes, absolutely. They were in line with my own investigation.
Thank you, Dr. Feldhaus. Your Honor, I've got nothing further.
Thank you, Attorney Debnoff. Attorney Anand, any redirect for this witness?
No redirect, Your Honor.
Thank you for your testimony this evening, Dr. Feldhaus. You are excused.
Thank you, Your Honor.
Attorney Anand or Attorney Volpert, any further evidence or testimony on behalf of the plaintiff?
No, Your Honor. With that, the plaintiff rests its case in chief.
Right, very good. I am showing the time is 56 minutes after the hour. Let's stand in recess till about 2 minutes after the hour.
Yes, Your Honor.
All right, we are going to go back on the record in the matter of Aaronsman versus Scanlon Screening Incorporated. I'll note the appearances are the same. I believe everyone is back from the break. Is that correct? Either Attorney Anand or Attorney Volpert?
Yes, Your Honor.
Okay, very good. Anything from either the plaintiff or the defendant that needs to be taken up outside the presence of the jury before we begin the defendant's case in chief?
Nothing from the plaintiff, Your Honor.
Nothing from the defense, so Your Honor, we're ready to call our first witness.
Okay, very good. We'll go back in the presence of the jury, and Attorney Ashlock, you may call your first witness.
Yes, Your Honor. At this time, the defense calls Dr. Jazz Patterson to the stand.
All right, good evening, Dr. Patterson. I'll remind you, you've previously been sworn. Attorney Ashlock, go ahead when you're ready.
Yes, Your Honor. Good afternoon, doctor.
Good afternoon.
Could you please introduce yourself to the members of the jury?
Hi, everyone. I'm Dr. Jazz Patterson.
What do you do for a living, Dr. Patterson?
Right now, I'm working as a healthcare consultant, taking a break from the 9 to 5 at the MDA. That's the Midlands Drug Administration. I was a senior researcher there.
What did you have to do to become a senior researcher at the MDA?
I got the job because I published several articles on infectious diseases. Prior to that, I earned my bachelor's in chemistry in 2012 and my medical degree in 2015.
Dr. Patterson, how did you get involved in this case?
I was hired to review the report of Dr. Feldhaus.
Could you remind the members of the jury who Dr. Feldhaus is?
Sure. Dr. Feldhaus wrote a report on the effectiveness of Scanlon's COVID tests. It was my job to see if there were any problems with that report.
Well, I want to talk about the steps you took going through your evaluation. What kind of materials did you have access to when you were working this case?
I had a complete copy of Dr. Feldhaus's report, so all of his experimental data, as well as all of the conclusions that he attached.
Do you use some kind of method when you're reviewing another scientist's work?
Yes, I use the target method. It's standard at the MDA for reviewing experiments.
Why is it called the target method?
Imagine you're playing darts. In order to accurately hit the bullseye, you have to take into consideration several factors, like how hard you throw the dart, how fast you throw the dart, and the angle that you throw it at. In a similar way, researchers using the target method have to consider a variety of statistical factors when reviewing experiments.
What kind of statistical factors do researchers have to review?
Anything from strict guidelines to sampling to containment procedures. Those are all factors that researchers consider when using the target method.
Is the target method reliable?
Yes, it's the gold standard in my field, and it was commonly used at the MDA.
Did you reliably apply the target method for your work in this case?
Yes, I followed the target method exactly as it's laid out.
At this time, Your Honor, we're going to be pulling Exhibit 13 on screen. It's already in evidence. Dr. Patterson, I want to spend our time today talking about whether or not Dr. Feldhaus hit his target. What are we looking at on screen here?
This is Dr. Feldhaus's data about Scanlon's COVID-19 test kits versus 3 of its competitors. What Dr. Feldhaus did was he ran an experiment comparing Scanlon to each of them.
Were there any issues with his experiment?
One very noticeable problem, but I think this chart is a little hard to read. So I brought along a little chart of my own.
Your Honor, permission for Dr. Patterson to display his chart. Opposing counsel's already seen.
That's fine.
All right, Dr. Patterson, let's start with results. How did Scanlon screening do in Dr. Feldhaus's experiment?
At first glance, pretty bad. When identifying positive samples of COVID, Scanlon got 53%, a competitor got 71%, another got 82%, and a third got 88%.
Well, Dr. Patterson, Does this mean that Scanlon test kits are inaccurate?
I can't be certain of that. No.
Why not?
Take a look at these red dots. These dots represent the number of tests that Scanlon got wrong. The problem is that Scanlon only got 3 more tests wrong than competitor 1, but that took them down by a whopping 18%. Competitor 2 only got 2 more samples right than competitor 1, but that took them up by a full 11%. And competitor 3 only got 1 more right than competitor 2, but that still brought them up by 6%. The big overall problem here is that Scanlon was only tested with 17 positive samples in this experiment.
Is there a term for that kind of problem in your field?
Yes, this is what we would call a sample size issue. It's like judging a book by the first few pages.
Objection, Your Honor, to improper character testimony or expert testimony. May I be heard?
Yes, please go ahead.
According to case law, Kane's software code v. Mars investigation, an expert witness can only testify on direct examination to conclusions that they listed out in their report, in their expert report prior to trial. Now, Dr. Patterson certainly listed one of his conclusions, saying that 50 COVID samples were not, or that Dr. Feldhaus could have used more than 50 COVID samples in this experiment. He did not, however, say that 17 positive samples were insufficient for Dr. Feldhaus to use. However, that is the conclusion that Dr. Patterson just stated on direct examination.
May I be heard as that, Your Honor?
Please do.
Your Honor, in order for expert testimony to be excluded under Kane software versus Mars investigation code, the conclusions and the underlying data and facts supporting them can't be contained anywhere in the expert's report. That's not the case here. Dr. Patterson explicitly says in his report that there was a sampling issue with Dr. Feldhaus's experiment, and more specifically, that more samples were required. Now, pursuant to opposing counsel's objection, Your Honor, he referenced 50 samples because those were the samples in the overall experiment, but we're focusing on the 17 positive ones from those 50 samples. This is contained in the report prepared by Dr. Patterson and therefore is admissible.
May I respond, Your Honor?
Please do.
Once again, the conclusion listed in Dr. Patterson's report is that 50 samples constituted a sampling issue for Dr. Feldhaus's experiment. This entire demonstrative shows the problem with 17 positive samples. And that is the testimony and conclusion that Dr. Patterson is giving right now. I can screen share Dr. Patterson's report, expert report, if opposing counsel would like to point to where that conclusion is listed, allowing this testimony to come in on direct examination.
Attorney Anand, are you asking to do a voir dire examination of this witness?
Simply to this conclusion under case law Kane software, yes.
Okay, go ahead.
Good afternoon, Dr. Patterson. Could I ask you wrote an expert report prior to trial, correct?
Yes, I did.
And you included every relevant conclusion in that expert report.
Yes, I did.
And in that expert report, you didn't mention that 17 positive samples were insufficient for Dr. Feldhaus's experiment, did you?
I wouldn't quite put it that way, sir. I had a problem with 50 samples, and I thought those were a little too small. And 50 is a problem, 17 is too.
Let me ask you again. My question was, in your expert report, you never state that 17 positive samples were insufficient for Dr. Patterson's conclusion. Is that correct?
I don't use the exact phrasing of 17. I do say that 50 is an issue, so it's implied.
So you don't explicitly state that 17 positive samples were insufficient. Is that correct?
No, just to the 50.
Thank you, Dr. Patterson.
May I be heard, Your Honor?
Go ahead.
The specific experiment that opposing counsel is inquiring as to is a 50 sample experiment. And in Dr. Patterson's report, He specifically states that he has a sample size issue with that 50 sample experiment. The 17 positive COVID samples were a part of that 50 sample experiment. He clearly states that there's a sample size issue with that experiment in his report. This testimony is not inadmissible pursuant to Kane Software versus Mars Investigation Code.
Brief response.
Very brief.
Dr. Jazz Patterson just stated that he didn't state that 17 positive samples were insufficient in his expert report.
You know, this is a very close call for the court. Obviously, the expert report that Dr. Patterson prepared does speak about the issue with the sample size of the 50 tests. The court is concerned by the witness's testimony just now that his conclusion ought to be implied from the expert report. The standard set forth in Kane Software versus Mars Investigations does not seem to purport to support implied conclusions. It requires express conclusions. That being said, the issue of sample size was raised in the expert report. I'd encourage, I'm not going to exclude anything that's been testified to so far, but I'm going to direct Attorney Ashlock to move on to the next area of testimony.
Yes, Your Honor.
Yes, Your Honor. Your Honor, clarification as to your ruling.
Go ahead.
Can we continue to inquire to Dr. Patterson as an overall sampling issue and just avoid the issue with 17 samples?
Yes.
Yes, Your Honor. Now, Dr. Patterson, in the totality of his experiment, Dr. Feldhaus used 50 samples. How many samples will be required for someone to be confident about their conclusions from this type of experiment?
Dr. Feldhaus himself has said that he would have needed at least 450 more samples in order to figure out the cause of the discrepancy that he identified.
Well, Dr. Patterson, did Dr. Feldhaus ever run this experiment again with the extra 450 samples?
No, he went to the press with just the numbers that he got from that 50.
Dr. Patterson, do you know who someone named Mr. Chase Aaronsman is?
Yes, Mr. Aaronsman was referenced in Dr. Feldhaus's report. From what I remember, Mr. Aaronsman said that he had run an experiment proving that Dr. Feldhaus's, that Scanlon's test kits were faulty.
Well, Dr. Patterson, based off of what you read in Dr. Feldhaus's report, did Chase Aaronsman ever send some kind of lab report to Dr. Feldhaus?
Dr. Feldhaus didn't attach any lab report from Mr. Aaronsman.
Based on what you read, did Chase Aaronsman ever send him any samples?
Once again, there were no samples from Mr. Aaronsman mentioned in Dr. Feldhaus's report.
Dr. Patterson, did Chase Aaronsman even send Dr. Feldhaus any pictures?
No.
Objection, Your Honor, to lack of personal knowledge. May I be heard?
Go ahead.
In the previous two questions, Attorney Ashlock had specified based on what you read. In this final question, opposing counsel just asked, did Chase Aaronsman send Dr. Feldhaus any pictures? I would just ask that the phrasing be amended based on what Dr. Patterson read in Feldhaus's report.
That's fine. Attorney Ashlock, if you would rephrase the question.
Yes, Your Honor. Dr. Patterson, based on what you read in Dr. Feldhaus's report, did Chase Aaronsman ever send any pictures of this alleged experiment?
No.
Thank you for your time, Doctor. I have no further questions, Your Honor.
Thank you, Attorney Ashlock. Attorney Anand, you may proceed with your cross.
Yes, Your Honor. Good afternoon, Dr. Patterson. I just want to start by looking at your investigation. Now, you reviewed the expert report of Dr. Brent Feldhaus.
Good afternoon, Mr. Anand, and yes, that's right.
But you, Dr. Patterson, didn't interview any witnesses during your investigation.
That's correct.
And you, Dr. Patterson, didn't conduct any examinations of physical evidence.
That's right. In an investigative review like this one, we typically just look at what the investigator, in this case, Dr. Feldhaus, considers to be sufficient for their experiment.
And you, Dr. Patterson, had sufficient evidence to form your conclusions in today's case.
Yes, that's right.
But on direct examination, you concluded Dr. Feldhaus didn't have enough evidence for his expert conclusion.
Not exactly. I said that Dr. Feldhaus would have needed 450 more samples to determine the cause of the discrepancy that he identified.
But to be clear, Dr. Patterson, Dr. Feldhaus doesn't conclude the cause of the inaccuracy of the safe strip, does he?
That's right.
And Dr. Feldhaus, he did interview a witness during his investigation.
I believe he spoke to Mr. Ahrensman. That's right, sir.
And Dr. Feldhaus, he did conduct an examination of physical evidence.
If you're referring to the experiment, that's right, sir.
Now, Dr. Patterson, I just want to point out what you and I actually agree about. You believe Dr. Feldhaus conducted a thorough and complete investigation.
Absolutely. I think that he did a fantastic job. My issue was just with the sample size and the interpretations.
You also believe he arrived at impressively sound conclusions.
That's right, sir.
You have no reason to believe that Dr. Feldhaus's analysis of the safe strip and its competitors was performed improperly in any way.
Not from the experiments or the information that he attached from his report. That's right, sir.
And you would agree with me, Dr. Patterson, that the safe strip being less reliable than its competitors is the most likely conclusion in today's case.
That's right. Based on the limited amount of information that we have, you're correct.
So let's talk about why you're here today, Dr. Patterson. You were hired by Scanlon Screening.
That's right.
You were paid to review the expert report of Dr. Feldhaus.
Yes, I was paid for my work.
And you're being paid to testify in court today.
That's right.
You charged $700 an hour for your work?
Yes, that's correct.
That's $100 more than the industry standard, am I right?
Yes, I had to fly out here as well, so I charged the extra 100.
Well, you actually also charged Scanlon an extra $30,000 for your travel and testimony.
Right, that was the flat rate.
And you actually have a personal connection to this case, don't you, Dr. Patterson?
I'm not sure what you mean.
Well, Emerson Moon is the founder of Scanlon Screening.
Yes, that's right.
Emerson Moon is also an old friend of yours.
Yes, we took an art class together back in high school.
And Moon also told you that if the safe strips were found to be faulty, it would reflect badly on your friends at the MDA.
That's what she said. That's right.
Not only that, doctor, but your own daughter this year submitted an application to intern at Scanlon Screening?
Yeah, that's her new inspiration. Last summer, she was working at NASA, and then she decided she wanted to go to the vet's office, and now she's convinced she wants to be a medical tech worker.
So let me get that right. Your daughter applied to Scanlon Screening this year?
That's right. And I think she'll get the job. She's got good grades, leadership. She's a fantastic daughter.
Thank you, Dr. Patterson. I have no further questions.
Thank you, Attorney Anand. Attorney Ashlock, any redirect examination for this witness?
No redirect, Your Honor. We just asked that Dr. Patterson step down.
Thank you for your testimony this evening. Dr. Patterson, you are excused. We'll allow the jury to collect their thoughts. And while they're doing that, Attorney Debnoth, you may feel free to call your next witness.
Yes, Your Honor. The defense calls Emerson Moon.
And we'll wait for just a couple moments here to allow the jury to finish up their notes, and then I'll invite you to proceed.
Yes, Your Honor.
All right, Attorney Debnoff, please go ahead with your examination. And Ms. Moon, I'll remind you, you've previously been sworn.
Good afternoon. Can you introduce yourself to the members of the jury?
Good afternoon. My name is Emerson Moon.
Ms. Moon, what do you do for a living?
I'm the co-founder and the COO of Scanlon Screening.
Can you tell the members of the jury why you started Scanlon Screening?
Sure. Back when I worked in college, I was an intern at Kaiser Permanente, and it really opened my eyes as to how our healthcare system, it needs to be more accessible. So I started Scanlon to do just that. One of our most well-known products is our COVID test. We call it the Safe Strip.
Well, ma'am, before we get into your work at Scanlon, I want to talk about what we all heard today. Have you been on this Zoom call throughout trial?
I have.
Ma'am, did you hear Mr. Ahrensman and Dr. Feldhaus say that your company created faulty tests?
I did hear them say that.
So, Ms. Moon, I have to ask, would you ever have your company create faulty tests?
No, of course not.
Why not?
I mean, for starters, it's a major public health hazard. People's lives are at stake. But it's not smart business.
Well, what do you mean by not smart business?
If the MDA were to find out we had issues with our product lines or error rates, we could get shut down within a month. It makes more sense for our long-term growth at Scanlon if our products do what we say they do.
So, ma'am, with that in mind, I want to talk about the reason that Mr. Ahrensman was fired. Ma'am, did you hear him testify that he was fired for coming forward about faulty tests?
I did hear him say that.
Is that true?
No.
So why did you fire Mr. Ahrensman?
There were multiple reasons. I saw a lot of my younger, more eager and ambitious self in Mr. Ahrensman. He was constantly asking.
Objection, Your Honor, to character evidence. May I be heard?
Go ahead.
Your Honor, the witness just testified that she saw the ambition within herself in Chase Ahrensman. She's using this to show a character trait, ambition, to show that he acted in conduct and conformity therewith, in being ambitious, wanting that promotion, and therefore lying about faulty COVID tests.
Attorney Debnoff, what's your response?
Yes, Your Honor. For this to be inadmissible character evidence under Rule 404A, we'd have to be showing some sort of prior act that demonstrates conformity with a character trait. We're not doing that in this case. Ms. Moon is only saying that she perceived a lot of herself in Mr. Ahrensman and then went on to have a disgruntled relationship with her thereafter. There is no inadmissible character evidence here, Your Honor.
A brief response, Your Honor?
That's not necessary. The court is prepared to rule. I agree. I'm not hearing a prior bad act. I'll note that we have not heard the entirety of the witness's response yet. So if we do hear that improper character evidence, you may re-raise the objection, but based on what I've heard so far, the objection is overruled.
So, Ms. Moon, did you get a chance to finish your answer?
I was just saying that I saw a lot of my younger self in Chase. He was constantly asking for promotions, and each time I would sit down with him, have coffee, and talk about his long-term plan at Scanlon. But eventually, he took it too far. It got to be too much.
What do you mean when you say it got to be too much?
He started sending me these threats. There were 3 notes, one in late September on the 30th.
Objection, Your Honor, to speculation. May I be heard?
Go ahead.
Your Honor, the witness just characterized the notes that she received from Chase Ahrensman as threats. This is going into the mindset of Chase Ahrensman when he wrote that note. Therefore, it calls for speculation. Or I'm sorry, it is speculation.
Attorney Debnoff, your response?
Yes, Your Honor. Under Rule 701A, a lay witness can testify to that which they rationally perceived. Now, Ms. Moon was on the receiving end of these notes. She read the contents of those notes, and so she can testify that she perceived these notes were threats. She's not entering the mindset of Mr. Ahrensman in this case.
Response to those grounds?
No, I agree. The objection is overruled.
So, ma'am, did you get a chance to finish your answer about why it got to be too much?
I was saying that I received 3 threatening notes from Chase. The first was on September 30th. The second was in early November, I believe the third, and that last one was on November 27th. He kept saying he was going to go to the MDA if I wouldn't promote him.
Ma'am, was there any other reason that you fired Mr. Ahrensman?
One time in later November, and he came running into my office. He slammed open my door and was going on and on about how he found some faulty COVID tests.
What did you do after you heard about faulty COVID tests?
I mean, if Chase was right, that's a really serious issue. So I asked to see those tests. But he said he didn't have them anymore.
Well, did Mr. Ahrensman say why he didn't have those tests?
He told me that he threw them away.
So, ma'am, after that conversation with Mr. Ahrensman, what did you do?
I decided to talk to all of my lab managers and have them test their batches of tests and report if they had any errors. None of them reported anything to me. And it appeared that Chase was lying about our COVID tests being faulty.
So, ma'am, you told us that Mr. Ahrensman, that he sent you threatening notes, that he might have lied about those tests, but was there any other reason you fired him?
Yes. In a conversation I had with Chase, he said if I didn't promote him right then and there, then he was going to falsify evidence and call a Dr. Feldhaus, and maybe he will be able to give him what he wants.
Well, ma'am, I do want to talk about Dr. Feldhaus. Have you ever seen him before he testified today?
I have. I didn't know it was him at the time, but I saw him standing at Scanlon right outside our doorway in fall of 2020.
And what was he doing?
I saw him passing out these flyers to all of our employees, mostly our lab managers. Chase Ahrensman was one of them.
Well, ma'am, how do you know that it was Dr. Feldhaus?
He had the same dark hair. It was the same man I saw testify earlier today. Same glasses, looked to be about 5'8".
Ms. Krishnan, can we get Exhibit 12? Now, ma'am, do you recognize this document?
I do. This is the flyer that I saw Dr. Feldhaus passing out that day.
Do you know what it was asking for?
It was asking about dirt and gossip about Scanlon. So this firm that's listed here, Hammett and Associates, can become our majority shareholder.
Now, ma'am, you mentioned that Dr. Feldhaus was speaking to Mr. Ahrensman. Did you hear any of what they said?
I did. I heard Dr. Feldhaus say how he planned to talk to his investor in order to get Chase a promotion if Mr. Ahrensman could whip up any faulty tests.
Thank you, Ms. Moon. Your Honor, we've got nothing further at this time.
Thank you, Attorney Debnoff. Attorney Volpert, you may proceed with your cross.
Yes, Your Honor. If I could just have a second to fix my camera angle.
That's fine. Take as much time as you need.
Good afternoon, Ms. Moon.
Good afternoon.
Now, I want to start by talking about something you told us on direct examination.
Okay.
You told us that Chase Ahrensman came to you and told you that your COVID tests were faulty, right?
He did.
You told us that you asked to see those tests. You wanted to know what they were like, right?
That's exactly right. I wanted to see the test for myself.
Right, because you wanted to see if they were actually faulty. Isn't that right?
That's right.
Well, Ms. Moon, one really easy way that we could know if those tests were faulty is if you showed us the data, right?
The data that we collect from our tests?
Yes, the data you have on your own product, the SafeStrip.
Yes, ma'am. However, that data is auto-cleared from our system every 2 months due to MDA guidelines and HIPAA privacy laws.
That's right. You don't actually have that data because you deleted it. Isn't that right?
Oh, I didn't delete it, ma'am. Our system auto clears it due to those HIPAA privacy laws.
Well, I just want to be very clear. After you learned that this lawsuit was happening, you didn't make your system stop deleting that data, did you?
No, it would be illegal to do that.
So that's a yes to my question. Your system's been deleting data on the safe strip up until trial today. Isn't that right?
Of course.
Now, Ms. Moon, I want to talk about why we're in court today. Now, Scanlon put out a press release on February 16, 2020, right?
That's right.
You would recognize that press release in court today if I were to show it to you?
I would.
Your Honor, let the record reflect we're now screen sharing Exhibit 3, which has been pre-admitted. Now, this is that same press release, right?
Yes, it is.
It was put out on February 16, 2020, right?
That's right.
Now, in this press release, Scanlon says, the regulators determined that we have the fastest, safest, and most accurate option. Did I read that correctly?
Yes, you did. Every word.
Well, Ms. Moon, you were in court today when Dr. Feldhaus testified, weren't you?
Yes, I did hear Dr. Feldhaus testify.
You heard him say that he compared the accuracy of the safe strip to your competitors, right?
Yes, I believe he talked about an experiment he ran.
Right, and Dr. Feldhaus testified on the stand today that the safe strip was less accurate than every single competitor that he tested it against. You heard that?
Yes, I do believe Dr. Feldhaus said that.
Now, Chase Ahrensman actually told you that those tests were faulty, right?
That's right, back in November.
And Ms. Moon, you fired him for it, didn't you?
No, I didn't fire him because he told me the tests were faulty, but because I later found out he was lying about those tests.
Right, is it your testimony today? You told us on direct examination that you fired Chase Ahrensman because he was making threats. Is that right?
That's right.
Well, you remember writing a termination memo to Mr. Ahrensman, right?
I do. That was in late November.
Right, you would recognize that memo in court today if I were to show it to you?
I would.
Your Honor, let the record reflect we're now screen sharing Exhibit 8, which is also pre-admitted. Now, Ms. Moon, using the annotation feature, could you just point me to where on this termination memo that you ever said anything about threats?
Oh, I didn't list any reasons on this memo. Our HR department doesn't require that we do when we let somebody go.
So, Ms. Moon, you don't say the word threats on this memo once, do you?
No, I do not.
The only thing you said after telling Mr. Ahrensman that he was fired was that you banished the rat. Did I read that correctly?
That's right, ma'am. With this line, I was referencing all of the lies he'd been telling us while he was working for us.
Well, I'm not asking what you meant by that line. I'm just asking if I read that correctly. It says that you banished the rat, right?
Yes.
Now I want to talk more about these threats that you told us about on direct examination. Now that first note that you received, that was from September 30th, 2020, right?
That's right.
You didn't fire Mr. Ahrensman on September 30th, did you?
No, not at that point. I thought I'd give Chase a couple more chances.
Well, you received that second note on November 3rd, 2020, right?
That's right.
You didn't fire Chase Ahrensman on November 3rd, did you?
No, it wasn't until I found out that he had been lying to us about our COVID test being faulty that I realized that that was the final straw, and I had to let him go.
Ms. Moon, that's a yes to my question. You didn't fire Chase Ahrensman on November 3rd, did you?
No, I did not.
So that's two notes that you received from Mr. Ahrensman that you didn't fire him for. Is that right?
That's right. I didn't fire him right after those notes were sent.
Let's talk about what changed. On November 26th, 2020, Chase Ahrensman came to you and told you that your tests were faulty, right?
He did.
5 days later, you fired him.
That's right.
Thank you, Your Honor. No further questions.
Thank you, Attorney Volpert. Attorney Demnoff, any redirect for this witness?
No redirect, Your Honor. We just ask that Ms. Moon can be excused.
Thank you, Ms. Moon. You may take your seat with your attorneys. Attorney Debnoff, any further evidence or testimony on behalf of the defendant this evening?
No, Your Honor. The defense closes its case in chief. If it's amenable with Your Honor and the other side, we'd ask for a brief 10-minute break before closing arguments.
So I've currently got 37 minutes after the hour. Let's make it 45 minutes after the hour to be back here for closings.
Yes, Your Honor.
All right, we are back on the record in the matter of Aaronsman versus Scanlon screening. The appearances are the same. Is there anything from either side that we need to take up before bringing the jury back in?
No, Your Honor.
And nothing from the defense, Your Honor.
All right, very well. Attorney Anand, you may proceed with your closing argument whenever you're ready.
Yes, Your Honor. 300 days. That's how long Chase Aaronsman told you he worked for Scanlon Screening. But 5 days? That's how long Emerson Moon told you she waited to fire Chase after he reported their faulty tests. Good afternoon, Your Honor, members of the jury. My name is Gervin Anand, and I'm here to remind you of what's really important in today's trial. Scanlon Screening put the public, every single citizen of Midlands, in danger. They lied to us, told us we should feel safe because their COVID tests were the most accurate out there. But in reality, the safe strips are anything but safe. Chase Aaronsman found out about the defendant's secret. He came forward with what he discovered, hoping to protect the public from Scanlon's lies. And for that, he lost his job, his reputation shattered, his career destroyed, all because he tried to do the right thing. Now, as the plaintiff, we had a burden to prove this to you by a preponderance of the evidence. That doesn't mean you need to be certain. You just need to believe it is more likely than not that Scanlon falsely advertised their COVID tests and that Chase Aaronsman was fired for exposing that fact. At the start of this trial, my co-counsel Katie Volpert asked you 3 questions. 1, what did Scanlon say? 2, were those words true? And 3, why was Chase Aaronsman fired? So what did Scanlon say? Well, we showed you a press release sent from Scanlon Screening to the public. It specifically says we have the fastest, safest, and most accurate option to keep you safe. There is no doubt that Scanlon claimed to have more accurate COVID tests than its competitors. So were those words true? Well, you heard 2 experts in the medical field testify on the stand tonight. When Dr. Feldhaus came up here, he explained how he compared SafeStrip and 3 of its competitors. The results were definitive. And not only was the SafeStrip not the safest and most accurate option, as they claimed, they were by far the worst test, only correctly recognizing COVID 50% of the time. You even heard Chase Aaronsman describe his own tests of the SafeStrip. You heard the exact same result. Scanlon's tests only identified COVID 50% of the time. Just think about that for a second. I mean, these tests only work half of the time. Why should the public ever buy a SafeStrip? I mean, they could just as easily let a coin flip decide if they're sick with COVID. Data, tests, proof, that is the evidence we brought you. What did the defense bring you? They brought you a close, personal friend of the defendant. They brought you someone paid well above the industry standard for their testimony. They brought you a Dr. Jazz Patterson. But what they didn't bring you was any physical examinations, any witness interviews, frankly, any evidence at all. So I'll ask you again, members of the jury, were those words true? Well, you could choose to believe Dr. Feldhaus and the mountain of evidence that concludes Scanlon's safe strips were not, in fact, more accurate than its competitors. Or you could even believe the defense's own expert witness, who admitted on the stand that the most likely conclusion was that Scanlon's tests just weren't as good as their competitors. Either way, the answer is no. The answer is that the defendant, Scanlon Screening, put out false advertising for the safe strips. They lied to the public and they violated the law. But the only question left is, why was Chase Aaronsman fired? Well, he worked at Scanlon Screening for 300 days. And for 300 days, He never received a single negative performance review. As a matter of fact, he was even promoted. For 300 days, his boss, Emerson Moon, never brought up a single complaint. 300 days he worked for Scanlon, but only 5 mattered. It was the 5 days between November 26th and December 1st that changed everything. You see, on November 26th, Chase Aaronsman told the defendant that the safe strips weren't accurate. 3 days later, the defendant saw the exact story covered on the news. And just 2 days after that, Chase Aaronsman got a memo. He was being fired. And the only reason given? Well, the defendant had banished the rat. When Emerson Moon came up to testify today, she tried to tell you that Chase exposing the defendant's faulty tests, that wasn't the reason he was fired. Moon tried to tell you Chase was fired for blackmail. But members of the jury, that simply isn't true. Moon alleged that Chase blackmailed her with a note sent on November 3rd. The defense expects you to believe that Moon was so scared of Chase's aggressive threats that she had no choice but to fire him. But the defense also expects you to believe she waited a whole month to fire this employee who was actively blackmailing her? I mean, why would she do that? The answer is that she didn't. The answer is that those notes didn't matter. The answer is that only 5 days mattered. Chase Aaronsman was fired because he told the truth that Scanlon screening broke the law. The most likely conclusion is clear. Now I ask you, members of the jury, to finish what Chase lost his job for. Protect the public and find the defendant liable. Thank you.
Thank you, Attorney Anand. Attorney Debnoff, you may proceed with your closing argument whenever you're ready to do so.
Yes, Your Honor. What does someone do when they need a favor? When there's something they need and there's no way for them to get it themselves. They might ask nicely, they might say please. Or they might make a deal and get someone else to help them. But favors, they don't always come free. I mean, we see it all the time with kids swapping candy for Halloween, or when your coworkers team up with you on a project. Because that's what people do when they can help each other. That's what people do when each person has something the other wants. They make an equal exchange. But members of the jury, before we talk about what that equal exchange means for this case, I want to talk about the burden of proof. You see, plaintiff's counsel, they got up here and tried to convince you that all they have to do is tip the scales in their favor, and you have to find our client liable. But that's not quite how it works. Because at the beginning of this trial, the plaintiff, they started with nothing. And they had to work their way up, fact by fact, until they proved to you that their version of what happened, it's more likely than every other possibility combined. But what evidence do they bring you to meet that burden? No angry customers. No other employees who found issues. Nothing about the MDA pulling the product off the shelves. No, what they brought you were 2 witnesses who had everything to gain if Scanlon went down. 2 witnesses who had everything to gain from helping each other. Members of the jury, the only 2 witnesses that they brought you are 2 people who made an equal exchange. So let's talk about those 2 people, Mr. Aaronsman and Dr. Feldhaus. Now, when my colleagues spoke to Mr. Aaronsman, we found out why he was really here. Dr. Feldhaus sent him this letter that promised a reward, that promised that promotion that he'd been chasing. In exchange for dirt on the company, he'd get everything he was working for. It was an offer he couldn't refuse. So Mr. Ahrensman, he does what he has to do. He lies. He picks up the phone, calls Dr. Feldhaus, says, yes, there are issues with the test strips. They keep producing false negatives. Members of the jury, those tests, those false negatives, well, those are supposed to be the plaintiff's smoking gun. But for whatever reason, Mr. Ahrensman has no evidence of those tests. Members of the jury, they didn't bring you a single data set, a single lab report, even a single photo of those apparent false negatives that Mr. Ahrensman claimed to find. But if you were telling the truth, wouldn't he have documented it? If Mr. Ahrensman were suspicious enough to run an entire experiment in the first place, why would he stop short of actually collecting the evidence that he needed? Simply put, that evidence doesn't exist. But let's talk about Dr. Feldhaus's part in the equal exchange. Now, members of the jury, we learned today that Dr. Feldhaus, he was paid by a client to investigate Scanlon, that client wanted to buy out the company. So Dr. Feldhaus, he took the stand and he showed you this graph. Told you that Scanlon had just a 53% accuracy rate at detecting COVID-19, shockingly low, right? But what he was hoping you wouldn't notice, what we had to find out from Dr. Patterson instead, is that number, 53%, it's based off of 50 samples overall and only 17 positive ones. Members of the jury, both experts in this case, they agree that amount of samples, it wasn't enough. So if that's the case, if Dr. Feldhaus knew that was the case, why did he stop at the numbers that he had? Well, members of the jury, we saw that Dr. Feldhaus, he wasn't looking for honest information on the company. No, he was looking for gossip, rumors, any bad information on the test kits that he could find. To meet the demands of the person lining his pockets, he just needed any dirt on the company. It didn't matter if it was true. So when Mr. Ahrensman calls him, tells him exactly what he's hoping to hear, exactly what his investor paid him to find out, he doesn't pause to question it. He doesn't ask for proof. No, members of the jury. Dr. Feldhaus, he was bought to create controversy. So he did. But let's say you don't believe us. Let's say you're convinced that those tests were in fact faulty. Even then, members of the jury, the plaintiff has failed to meet their burden, because they also had to prove to you that Mr. Ahrensman was fired only because he came forward about those test results. And to do that, they showed you this timeline. They told you that Chase Ahrensman worked at Scanlon for 300 days and that it only took us 5 days to fire him. But members of the jury, the truth, it's not that Mr. Ahrensman uncovered some sort of conspiracy and was fired for telling people about it. No, it's a lot less exciting. Mr. Ahrensman was just a bad employee. He sent threat notes to Ms. Moon. First note in September of 2020. And then he sent another note in November 3rd of 2020. And then yet another note on November 27th of 2020. For 3 months, members of the jury, Mr. Ahrensman sent threat notes to Ms. Moon. And it was only after those 3 months, after the culmination of all those events, 4 days after that last note, Mr. Ahrensman was fired. Now, members of the jury, I want to take a look at a section from Scanlon's employee handbook. You don't have to be an expert in contract law to understand this. It says right here in this document that Mr. Ahrensman read and signed that if you're insubordinate, you can be fired. No questions asked. But here's the thing, members of the jury. The fact that Mr. Ahrensman was insubordinate, it's not even in contention in today's case. Mr. Ahrensman, he took the stand and he told you that he was insubordinate. And so the only reason he's here, the only reason that he's suing our client, well, he can't make money off of being insubordinate. But he can make money off the lies that he tried to sell you. Members of the jury, Dr. Feldhaus and Mr. Ahrensman, they made an equal exchange. They cannot be trusted. And if you can't trust the only two witnesses that they brought to the stand, then you have to find our client not liable. Thank you for your time.
Thank you, Attorney Debnoff. Attorney Anand, how much time do you have remaining for a rebuttal?
I believe 2:45. Could I get the timekeeper to confirm?
Yes, 2:45.
Thank you.
You may proceed with your rebuttal whenever you're ready.
Yes, Your Honor. Members of the jury, the defense has told you repeatedly that this case is all about an equal exchange. They expect you to believe that Chase just wanted a promotion, that he made up all of his evidence that the safe strip was faulty, he gave it to Dr. Feldhaus. But that can't possibly be true. The defense expects you to believe Chase only reported the safe strip after seeing Dr. Feldhaus's letter. But Chase ran his tests weeks before that letter and the promotion offer was ever sent. And when Chase did report those inaccurate tests, he didn't go to Dr. Feldhaus. He went straight to Emerson Moon. He went straight to his boss, putting his job on the line. He wasn't thinking about a promotion. He wanted to save lives, lives that the defendant endangered. And it was only after he was told by Emerson Moon, don't say a word about this to anyone, that he finally informed Feldhaus. And let's outline the exchange that actually took place. On one side, the media learns of Scanlon's faulty tests. The public learns the truth about the safe strip, and lives are saved. But on the other side, Chase Ahrensman's reputation, career, and his entire future in the industry was ruined in a day. He lost his job just 5 days after he came forward with the truth. Members of the jury, does that sound like an equal exchange to you? Well, if it doesn't, you must find the defendant liable. Thank you, Your Honor.
Thank you, Attorney Anand. We'll pause to allow the jury to complete their deliberations, and when they are all done, you will get to hear from them. But from now, you have the court's congratulations and well wishes on a job well done. So we'll pause here for just a few moments and be back with you shortly.
Judges, as you complete your ballots, if you'll turn your camera on, that way I know they've been submitted to the AMTA reps to check for completion. And then students, feel free to turn your cameras on whenever you're ready. That way, when the judges begin comments, we're all here. I think we're ready to go. So at this juncture, the AMTA representatives are going to be tabulating the ballots. As a reminder, the live stream will continue to run through the announcement of the winner of the round. We're anticipating it'll take approximately 5 minutes for the AMTA reps to complete tabulation. During this period of time, we ask that judges share brief comments and limit their comments to approximately a minute each, perhaps sharing, for example, their favorite moment of the trial. I'm going to turn it over to our judges. I'll start with Daniel Elliott.
Hi, everyone. Congratulations on a job well done. As Chance mentioned at the beginning, I'm an alum of Rhodes College in Memphis, who are your hosts for the 2023 National Championship Tournament. And so on behalf of the people who are planning that tournament for you all, congratulations. We look forward, if you keep up the kind of performance you gave tonight throughout this year, we will look forward to having you all in Memphis in April. I have 2 comments. They're both about witnesses. The first, I'm not sure what you mean. This is something that happens a lot in trial. Witnesses love this line on cross. But here's the thing. You do know what they mean because you also have read your material. And when you say something like, I don't know what you mean, you're really hitting you're really teeing up a grand slam for the crossing attorney. So take that away from them. Just don't give them that easy line. And the other thing, witnesses, don't be afraid to lean into the emotion that may come with some of this stuff. I think particularly your plaintiff, you were the person who created this test, and you suddenly find out the test is not accurate and it could lead to people, putting others at risk. That is an opportunity where you can sort of feel the gravity of that and express that to us in court, and it will look very human. So don't shy away from those emotional opportunities. Otherwise, great job, everyone. Look forward to seeing you in Memphis.
Thank you, Daniel. I'll hand it off to Liz Grant.
Hi, everyone. Congratulations. I know it's probably just as late for you all as it is for me, so I'll be brief. I'm going to do a highlight for the plaintiff and one for the defense. I think on the plaintiff side, I was really impressed by your command of objections and evidence. I think, Katie, you had an excellent distinction between 404A and 404B, and as an evidence junkie, I loved it. Likewise, Gervin, you had a really good Kane software argument that I was really impressed by, so good job to you both. On the defense side, I was really impressed with your vocal intonation and your articulation. I think, Rhea, you are a stunningly good speaker. Your closing argument, the vocal intonation was excellent, and I was very impressed. I'm very glad that having graduated, I'll never have to face any of you in a courtroom again, but I hope to see you all again soon, and congratulations for getting this far.
Thanks, Liz. Brandon, take it away.
Thanks, Amelia. Congratulations to everyone. You guys were fantastic. My one comment is an area where I think everyone can improve. I thought the round was really good. And one thing that I'm struck by, and it's becoming, I think, more common in AMTA, is that in particular lawyers are starting to take on a sort of trial affect or trial voice or trial persona, where a lot of people sound very similar and sort of are copying the intonation and pausing and speech cadence of others. And I think to the extent that you can work on just being yourself and talking like you would talk in the real world if you were just talking to your friends, you will be far more effective as an oral advocate because you will be comfortable. And as someone who is in courtrooms every single day, it shocks me how more effective I think litigants are when they are themselves. Obviously, you have to be professional and courteous and all of those things, but talking like someone else because you've heard them or you want to emulate them is always going to hold you back a little bit because you're never going to be totally comfortable until you're just yourself. I think it's one of the hardest things to do because we watch a lot of these videos and we watch really good AMTA alumni and really good lawyers and we want to be like them. But the people who are the best at this are stepping into their own shoes. And so my challenge for you all this year and in the future is to take these really good skills that you have and find your own voice and use that voice in the courtroom because it's going to be even more powerful if you're able to do that.
Thanks, Brandon. Danielle, the floor is yours.
Thank you again. I echo my fellow judges in congratulating you all. I'm not sure exactly like how much prep time you guys put into this being over the summer, but it was really apparent that you guys worked really hard on it, even with it not being, an official tournament that's, going to orcs or something. So kudos to all of you on putting in this time during the off season. Brandon actually took the advice right out of my mouth, what I was going to say. I think that because there's so much more footage available now for us to watch, we like see this sick thing that another competitor did and you're like, oh, I want to do that, which is so great. And I think particularly because you guys, this is the rookie tournament, you guys are still finding your styles. And so I definitely encourage you to take those cool things, but make them your own. And maybe that means it's a different phrasing or different pacing or different volume or different tone. In particular, I think that my number one comment, the more that I judge AMTA rounds as I've gotten like further and further out, is that AMTA competitors tend to not use the quiet moments as much as they can. I think we have a lot of building and maybe we'll get like one or two soft and slow moments in a trial. But I think the more you find that variation in your tone and that variation in your style, that's how you're going to make it more unique so that the whole trial doesn't kind of blur together as like, obviously you are all super competent and fantastic, but the more that you make yourself stand out, the more memorable you're going to be. So yeah, Brandon really hit the nail on the head with that one for me.
Thanks, Danielle. Sonali?
Hi guys, congratulations. I did this tournament when it was for seniors in 2020. I remember the chaos of trying to prep a tournament or prep a case in like 2 weeks over the summer when everyone was doing different things. So congratulations to you guys. I know how tough it is. I left comments on the ballot that I hope will be helpful going forward, just sort of general things. The one I want to say is I think both sides could have done a better job right at the beginning, like opens and first directs in like telling me what was going on. There was like lots of names coming, like lots of, and I don't know this case. I didn't know who these people were, what was going on. People used to say this to me all the time when I was competing. I never took it seriously. And now it's like the number one thing I say as a judge, because I think like you always know it way better than we do. And you can always do more to just like explain right at the beginning. I just wanted to shout out a couple of things I loved. Drew, I really liked your open. I think you have a really good style. It's really coming along in terms of developing a personality, dramatic and casual, and it feels personal too. So I really liked it. Rhea, I think you have a really nice balance of like seeming very polite while like simultaneously twisting the knife. Like I noticed on your objection before the voir dire in particular. I love that. It's great. Super hard to pull off. Katie, like Liz, I also loved your objections throughout. I think you were right on and not just right and clear, but also very concise, which is rare. So I think you did a great job with that. And Gervin, two things, like great job with the impromptu voir dire that I think you were not really asking to do, it seemed like. And also I really liked your rebuttal. I think your personality really came out. The drama came out. You made really good points. You felt the most relaxed I had seen you all trial. So think about like extending that energy the whole time because it was great. Thanks for having me.
Thanks, Sonali. Jonathan?
Thanks. I'll keep it real short. First, I would be remiss if I didn't make sure that we thanked Amelia and her planning committee for putting together this tournament. They did a fantastic job with like no oversight for me other than answering a few questions. I mean, I really just sort of handed them the keys and they went off and did this tournament. So they did a great job. Our case committee, I thought, wrote a really fun case. I hope you guys agree. So my thanks to those groups for really making this tournament happen. Brandon more or less took my comment. So the one thing that I will say, again, turning back to witnesses, one of the things that I really liked about this round was none of the 4 witnesses felt the need to do any sort of crazy, kooky, wacky witness character. I think there's some folks in this community who feel like at least one of your witnesses have to be a crazy, wacky witness in order to succeed. And I personally don't think that's true. And I really appreciated that all 4 of the witnesses here were very realistic and believable. As a result, you had great command of your particular materials, and that really showed through. And you didn't need to have a wacky accent or some drop in funny jokes or things to make your characters successful. And, with the fact that all the witnesses here were experts or professionals, I think a lot of times those sort of things are actually a distraction. But for the fact that you had 2 weeks to prep this and you're at this level, You all did a really amazing job, so congratulations.
Thank you, Jonathan. So our AMTA reps are finalizing the tabulation of the ballots right now. What I will share while they finish the last ballot is that it's gonna come down to that last ballot. If you'll hang tight with us for just a moment while we wait for final tabulation to come in, we'll share the results when the AMTA reps rejoin.
Can we go back to our war rooms with our team?
I'm anticipating that it's likely going to be less than like a minute and a half.
Gotcha.
So I don't know that there would be time to go back and forth. So I think staying in here might be the right call.
Bad question, Irvin.
My bad. I'm so sorry.
We can just reflect on the fact that we just watched a round that had 2 different voir dire examinations of experts. And I don't think that's ever happened that I've seen before. Maybe one of you has seen that, but I have not.
I'll be honest, I barely knew what a voir dire was.
Yeah, I have to sort of agree with both Jonathan and Gervin. Like, you know, I don't know that I would have been comfortable or would have known what a voir dire was when I was, you know, a quote unquote rookie, a freshman or a sophomore. So sort of like props to everyone. I think that all of the rounds, you know, this round in particular has felt, you know, nationals level.
Honestly, it really helped that Rhea did it first. If you could like roadmap for it.
We've gotten our results in, and our AMTA reps should be joining us in just a moment. Okay, we are good to go. I'll share ballot by ballot. The first ballot tonight went +5 to the plaintiff team. The second ballot went +3 to the defense team. The third ballot tonight went +6 to the plaintiff team, and the fourth +4 to the defense team. This brought it down to the one remaining ballot, our fifth ballot tonight. The winner of the 2022 Rookie Rumble is our plaintiff team, Team 8954. Team 8954, you won that last ballot by 2 points. Congratulations to both of our teams at the 2022 Rookie Rumble. Thank you to everyone for joining us this evening, whether you are in this room right now or you're streaming via YouTube.